All right, by court, no representation for Speaker of Parliament. We note also that the Speaker of Parliament has not filed any statement of case or memorandum of issues, despite the opportunity given for them to be filed. This matter is for hearing this morning. Can we hear counsel for the plaintiff?
My Lord, plaintiff filed a writ on the 15th.
We've noted all that you filed.
Okay.
If you don't mind, okay, spend fewer than 5 minutes, because we've noted the memorandum of issues, okay, and the matter set out.
My Lord, I will just argue. I will simply argue that any rule of interpretation that is used to interpret Article 97(1)(g) and H will lead to one conclusion with the accuracy of mathematics.
No. Any rule of interpretation used to interpret
Articles 97,
yes,
1G and H of the 1992 Constitution,
yes,
will lead to one conclusion with the accuracy of mathematics. That conclusion being that the intention of the framers of the Constitution was that the intention of the framers of the Constitution was that the act that grounded the vacation of office.
Did anyone vacate any office?
Pardon me?
Did anyone vacate any office? Let's stay true to the records.
Yes.
Please stay true to the records.
But on the ruling of the Supreme Court, that certain acts should be deemed to be a vacation of the office. The ruling of the Speaker, sorry. That certain acts.
Please listen to yourself, Ms. Agati.
Yes, please. The ruling of the Speaker.
Ms. Agati, listen to yourself.
Yes.
And speak concisely.
Okay.
We don't want any confusion this morning.
My Lord.
Is what you are going to say materially different from the articulation of that point in the statement of case?
What I'm saying articulates or amplifies what we said in the statement of case.
Except for your adding that it should be construed with the accuracy of mathematics.
Yes.
Which has made me apprehensive because it's social science.
Yes.
You must be mindful of what you are saying. This is social science. That's why I'm asking whether what you are saying has not been captured in the statement of case. For which reason we can adopt and we can then express ourselves.
My Lord, just that you adopt the statement of case, but to assist in your apprehension, I agree that this is social science. But my Lord, in this case, if it is interpreted in any other way, it will need to have validity. And the courts frown on that. That is our submission.
You are really that is better advocacy
Yes.
than what you earlier said.
I agree with you, my Lord. So this is social science. But any interpretation, any of the rules of interpretation, any of the rules of interpretation will lead to one conclusion. My lords, Article 97 was talking about one term of parliament, a particular term. 97 on vacation of office was talking about events happening in one term of parliament. And my Lord, therefore, Article 97, 1G and H will only take effect, or will only take effect if the act, that is the person, if the act, that is the person leaving a party by which was elected to join another party or to remain or to become independent and seeks to remain in parliament without new political coloration, so to speak. If the person leaves the party for which he was elected into parliament to join another party or to become an independent member of parliament and seeks to remain in that.
I don't think we need emphasis, Mr. Gatti. It's here, we'll read it.
My Lord, as directed by the court, I think our statement of case is self-explanatory. My Lord Tanko seems to be very happy. But as directed by the court, I think our statement of case is self-explanatory, and the purpose of this article will be undermined if it is given any interpretation other than the interpretation that has been given by the plaintiff. Thank you very much, my lords.
Honorable Gatti, just one point of clarification. Your relief 2.
Yes.
Is it still being maintained?
No. So our reliefs, some of our reliefs have been overtaken by the 10 of events.
Yes.
So we are relying on our relief 1.
Okay.
Simply.
Okay. So your relief 2, you are abandoning it?
Yes.
Okay.
The intention has become moot.
Okay.
It has become moot, my lord. Okay. This was found before the ruling was made.
Yes. So we needed to hear from you on that one.
Okay.
And I thought that is where you would have made articulated that point.
Please. My lord, we only are relying now on relief 1, A, B, and C. They are all taken over by them. Only 4. The omnibus clause, any further orders. Only 4. So 1, A, B, and C, and 4. That's fine. Well, most beautiful.
Thank you. Yes, indeed, I respectfully would like to advert the court's attention to Article 93, clause 1 of the Constitution. First, I would respectfully that even though the Scale Independence sets out 3 issues for consideration by the court, my respectful view is that the first issue that we set out for determination, which is that whether or not plaintiffs will properly impose the decision of the court, has in effect been disposed of by the court in its ruling dated the last agenda date.
Not entirely.
Right.
Be assured that it will be fully addressed.
Very well.
Not entirely, yes.
But the point I make is that on account of the argument advanced in court on 30th October 2024 and the ruling dated 30th October 2024, we did not find necessary this morning to go on with arguments under the first issue. They did rely on the arguments with the last agenda. Respectfully.
No. You cannot proceed like that. You cannot proceed like that because the last agenda, this panel did not hear you.
Right.
This is the panel that's hearing the substantive issues.
Yes. Yes. Right. Consider yes. The ruling.
And I also wondered what you were talking about. I was not on that panel.
So two members have been added. Yes. So I'll then quickly deal with issue one. The point to consider under issue one, respectfully, is that insofar as any matter borders on an interpretation of the Constitution and an enforcement of the Constitution, same is within the exclusive preserve of the Supreme Court. Article 2, Clause 1 makes this quite clear, and Article 130, Clause 1 reinforces it and indicates clearly that this principle is subject only to the High Court's jurisdiction in the enforcement of fundamental human rights. Article 130, Clause 1.
The High Court's jurisdiction
in an enforcement.
In the enforcement of fundamental human rights.
And that's Chapter 5. Respectfully, even the formulation of Article 130, Clause 1 indicates that insofar as an issue of interpretation arises out of a construction of any of the fundamental human rights provision, same will even come within the exclusive jurisdiction of the Supreme Court. That's one.
So even in the jurisdiction of the High Court on fundamental human rights, to enforce fundamental human rights, should there be a matter for interpretation that will come under the jurisdiction of the Supreme Court?
And I have as my authority the decision of the Supreme Court in the famous Nana J. Ampofo matter, which we have referred or cited in our Seymour case, and J. Ampofo versus Atendra. Again, it is reinforced by the decision of the court in Bedema.
Honorable Attorney General.
Yes, ma'am.
What you are telling us, is it not captured in your statement of case?
Yes, sorry, it is. I'm only addressing the court because my Lord Justice Tanko indicated at the last agenda date, those matters were actually not. I mean,
yes, but
this is the first time.
At the moment, we have your statement of case, all right? And that's what we are supposed to consider.
That's fine.
Good.
Yes.
So if it is captured in your statement of case, then you may spare us.
Right. So I'll then proceed to the second issue. And in addressing the court to the second issue, I'll refer the court to first Article 93, Clause 1 of the Constitution, which sets out the composition of Parliament. And says there shall be a Parliament which shall consist of not less than 140 elected members. This should be read as submitted respectfully with Article 47, Clause 1 of the Constitution, which says Ghana shall be divided into as many constituencies for the purpose of election of members of Parliament as the Electoral Commission may prescribe, and each constituency shall be represented by one member of Parliament. The combined effect of these provisions is that insofar as Parliament is constituted by a certain number of MPs or members of Parliament representing those constituencies, the composition of Parliament shall not be altered except as prescribed for in the Constitution. So no person or authority, with all respect, has the power to make any decision at all or construe the Constitution in a way which will alter or change the composition of Parliament, except as stated in the Constitution. Especially, I say that the matters before the court, apart from the meaning of Article 97, Clause 1, Paragraph G and H, also have an effect on the composition of Parliament, as prescribed for by the Constitution. So I also further contend, respectfully. Right.
The combined effect of Articles 93(1) and 47(1) is that insofar as Parliament comprises of constituencies as set out in the Constitution, that composition cannot be altered except in compliance with constitutional directions.
Precisely.
That's the point made?
Yes, just a little point. Comprises members of Parliament representing the constituencies. Because Parliament is actually composed of the members of Parliament.
Noted.
Especially, I submit that the composition of Parliament can only be altered strictly in accordance with the Constitution, and no person or authority has the power to change Parliament as duly composed or constituted, except in accordance with the procedures known to the Constitution. But I made the point that the matters in issue, with all respect, go beyond the mere meaning of Article 97, Clause 1, Paragraph G and H. They also have an effect on the composition of Parliament as anticipated by the Constitution. So, especially if a construction is placed on Article 97, Clause 1, Paragraphs G and H, with the result that the composition of Parliament is altered, and that construction is wrong, especially I submit that the constitutional order of the country has been upset. If a construction is based on Articles 97, Clause 1, J and H, and such construction is wrong, then respectfully, the constitutional order of the country has been unlawfully upset. And the second point I make respectfully is that everything in the Constitution, from the regulations affecting the performance of the Electoral Commission's functions, in Chapter 7, up to the composition of Parliament, or the entire chapter on the legislature, the entire chapter on the legislature in Chapter 10, shows that Parliament, when used, refers to a specific term.
Hold on, the word parliament.
Parliament, the word parliament. Parliament, when used, refers to only one term of Parliament in session, and nothing more. And that when the people of Ghana respectfully also elect a member of Parliament, when the people of Ghana vote in the election of members of Parliament, that election is for only one term. And they do not have in mind the election of members of Parliament beyond the term of Parliament for which they voted. Well, I refer to Article 113. Article 113 clause 113, clause 1 of the Constitution. And it says quickly, subject to clause 2 of this article, Parliament shall continue for 4 years from the date of its sitting, and shall then stand dissolved. Clause 2, respectfully, provides that at any time when Ghana is actually engaged in war, Parliament may from time to time, by resolution supported by the votes of not less than 2/3 of all members of Parliament, extend a period of 4 years, specified in clause 1 of this article, for not more than 12 months, except that the life of Parliament shall not be extended. So clearly, Parliament is for only 4 years and nothing more. My lady, this is further reinforced by...
Excuse me. Can you turn to page 24 of your statement of case, please? '23 and 24.
Oh, page 23.
Paragraph 32 and paragraph 33.
Yes.
Is what you are saying there?
Yes, respectfully, but I will further, I did not allude to clause 2 of Article 97, which I'm coming to. Respectfully, and clause 2 of Article 97 is very important. And so the point I make from all of this is that anything that affects the composition of Parliament for a future Parliament which has not yet been elected is unknown to the Constitution. The Constitution does not anticipate that all the matters set out in Article 97 clause 1, including J and H, which are an issue before the court today, have any bearing on matters beyond the life of a current Parliament. They have only consequences so far as the current Parliament is concerned with. Respectfully, apart from the clear or the indication in the language of Article 97 clause J, which talks about a person seeking to remain in Parliament, I will refer the court to Article 97 clause 2, which has not featured so far in the argument before the court. Article 97 clause 2 is in these terms: notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitutions or membership of a coalition government of which his original party forms part shall not affect the status of any member of Parliament. So if the point being sought to be made from Article 97 clause 2 is that even a merger of political parties in the life of any Parliament has no effect whatsoever on the status of a member of Parliament. Thus, if today the NDC and CPP, respectively, come together. Okay. But because I don't want to seem, okay, sound, right. So I would prefer a merger between the MPP and CPP as occurred in 1996. So respectfully, indeed, the implication is that if in the first Parliament of Ghana, the MPP had elected to contest parliamentary elections, which we all know from history that they did not, and in the course of the life of that Parliament, as actually occurred, a merger between CPP and MPP occurred. The status of a member of Parliament standing the ticket of MPP as an MPP MP shall not be touched, shall not be affected by the Constitution. So if indeed MPP and CPP had come by an arrangement, as they did actually in 1996, that for the Elembele constituency, the MPP will not contest, and the CPP rather will contest, which indeed was the case. But the MPP at that time already had a sitting member of Parliament in the Elembele constituency, and by virtue of that had more or less ceded his interest or right to a CPP member. Respectfully, that would not necessarily result in a vacation of the seat of the member of Parliament. So if indeed, on account of clause 2 of Article 97, it has been decided that for constituencies already held by the MPP, for the purpose of the upcoming election, those candidates or those members of Parliament shall contest on a ticket of CPP or a different political party. Article 97 clause 2 suggests clearly that the status of such members of Parliament as MPs shall not be altered. So especially this, in my respectful view, fortifies the proposition we make that any decision by a member of Parliament to change his political identity for an upcoming election shall not necessarily result in a vacation of that member of Parliament seat. I don't know if I'm making myself so I'm moving. So, right. Especially apart from that, I will refer the court to Article 47, Clause 5 of the Constitution, which is also a further indication. 47, Clauses 5 and 6 of the Constitution, which talks about alteration of the borders or boundaries of constituencies. So the point is that the Constitution, as I indicated, anticipates that the change in the composition of Parliament or the change in an anticipated composition of Parliament in the future shall have no effect presently. And that is supported by Article 47, Clause 5, which vests the Electoral Commission with the power to review the divisions of Ghana into constituencies at intervals of not less than 7 years, especially as we stand before the court. Indeed, the number of constituencies for the upcoming 2024 elections has been altered by the Electoral Commission. Rather than 275 constituencies, we will have 276 constituencies in the December 2024 elections because of the alteration of the boundaries of the Boem constituency, with the result that there has been a creation of a new constituency for what we call the Sao people, the Santo Kofi, Lolobi, and Akpafu area. Clearly, the alteration of the boundaries of the existing Boem constituency now has not affected the status of a member of Parliament sitting as MP in the Boem constituency. That alteration only has effect in the December 2024 elections. So the point I'm making with respect to that, it is so clear from the Constitution that whenever a member of Parliament decides to change his political identity, or indeed the Constitution itself seeks to enforce a change in the composition of Parliament for the next election, it has no effect in the current term. If that were the case, presently, the South people would vote now and elect their MP, but they cannot vote now and elect their MP. They must wait until December 2024. I'll quickly wrap up with a swift address of issue 3, which is whether or not the declaration by the Speaker of Parliament of 4 vacancies.
I have a question.
Right.
And my question is, what is the point of the provision in Article 97(1)(gh)? Why did the framers of the Constitution put them there?
Right. Right.
I know you have addressed it in your,
Yes.
if you don't mind. I know you have addressed it in your submissions, but I think that by reason of the last point made regarding Article 47(5), we need to have some light shed on
it. So the purport of Article 97(1) and G is to prevent situations where a person in the life of a current parliament seeks to alter his political identity. That is frowned upon by the Constitution. So that if a person comes to parliament or having been elected as a member of parliament for a specific term as an MPP candidate or whatever political party candidate, in the course of the term of that parliament wishes to move to a different political party, the Constitution says that's prohibited. If the person also seeks to continue, and that is indicated by the use of the word seeks to remain in parliament, if the person seeks to continue his tenure as an MP during that term of parliament as an independent candidate, that's prohibited by the Constitution. Indeed, such situations have occurred in this country. It is not without history or antecedent. So clearly, the Constitution anticipated a change of one's political identity within the term of the current parliament, and not an anticipation.
Mr. Dami, can you give us maybe 1 or 2 instances where
such occurred?
Exactly. Historical answers.
Right. Especially in the first parliament of Ghana, there were about 3 or 4 instances whereby my Lord, in the first parliament, there were 3 or 4, no, the first parliament, 1960, under the 1960 constitution, there were 4 instances in which some members of parliament cross-carpet or changed their political identity. There were the cases of J.A. Brima, Mumuni Baumia, Tampuri, and the Tolona. They cross-carpet from the then governing CBP to join a different political party. Others also cross-carpet from the opposition party to the governing CBP. In view of that, the court would note that the 1960 Constitution had no such provisions at all. In view of that, for the very first time, in 1969, a provision to that effect was enacted. And I refer the court to Article 75, Clause 2, Paragraph G of the 1969 Constitution. That's when it was introduced. It says every member of the National Assembly shall vacate his seat in the Assembly upon the dissolution of the National Assembly. A member of the National Assembly shall vacate his seat in the Assembly if J. he leaves the party of which was a member at the time of his election to the National Assembly to join another party. This was the first time, the Second Republic, that a provision like that was introduced. The provision again was repeated in 1979 Constitution, and it was at Article it was Article 79. Article 79, Paragraph I of the 1979 Constitution. I. It says, a member of Parliament shall vacate his seat in Parliament in I, if he leaves the party of which he was a member at the time of his election to join parliament to join another party. At the time of his election, to join another party. So that's it. Then the provision was repeated in 1992. Especially when the 1992 constitution took effect, a situation like that occurred. And I refer the court to the circumstance of Alhaji Wayo Seni, Professor Wayo Seni, who crossed carpet from the party on the ticket of which he had been elected as member of parliament to join another political party. At that time, the Speaker of Parliament indeed rightly ruled that he had vacated the seat. Especially this situation that we find ourselves in before the court had again occurred in Parliament, in the 7th Parliament. The Speaker of Parliament, just like the current Speaker, ruled that he had no vacation of seat. My respectful submission on that point is that such ruling was erroneous. The ruling that affected the status of Honorable Isiama Maledi, I laugh because the gentleman has suffered a lot. The last Parliament, he was declared to have been to have vacated his seat. This Parliament again, too, his seat has been vacated. One person. He suffered a lot. So, Maledi, and my point is that no matter the number of times an unconstitutional act is repeated, it does not ripen into constitutionality. This court has said in numerous cases.
So you are rounding up.
Yes, this court has said in numerous cases. It started from before the Attorney General up to the recent matter, I mean, ex parte charge or so. Yes, ex parte charge. 2007, 2008, Supreme Court of Ghana report, volume 1, at page 213, that an unconstitutional act, no matter the times repeated, especially, does not ripen into constitutionality. So the fact that the previous speaker had ruled that Mr. Isiama Mwaku had vacated his seat, and that is being sought to be used as a precedent today, does not mean that it's constitutional. Especially, I'll be done on this case.
You had only 3 issues.
Yes.
And you have addressed them.
Well, I say that the court has the power to issue orders, and the orders and directions issued by the court shall be binding on anybody at all. Ex parte charge held same. Republic vs. High Court, Fast Track Division, Accra, ex parte Commission on Human Rights and Effective Justice. Richard and the interested party. The court held at page 296 per Georgina Wood, CJ, that in relation to this matter, I think this was Dateba JSC stated that in relation to this matter, we need to remind ourselves that there is no parliamentary supremacy under our constitution. Rather, it is the constitution that is supreme. As the interpreter of that constitution, this court's view of the meaning of a constitutional provision cannot be preempted by that of any other agency of the state. In short, the provision in the constitution means what the Supreme Court says it means, and not what even Parliament has declared it means. I end on this note. The Supreme Court's power to interpret the constitution has been long upheld from Benjamin Awuno Williams, 1970, over 54 years ago, up to date. The constitution means what the Supreme Court says it means. End of matter. Thank you very much.
Zagati, it has been expressed that around the table that you are not allowed to speak, and yet the Attorney General has spoken extensively. I'm sure there's nothing you want to add. I'm very sure there's nothing you want to add.
My Lord, unfortunately, I agree with the sentiment that was expressed around the table, but I will not bore the court with adding anything.
We are grateful.
But I agree with the sentiment that was expressed. I think the Attorney General extensively referred to matters that was in statement of case without it being stopped. But you know,
because why are you pointing there? The sentiment actually came from this side. Yeah, so you seem to be thinking it came from there.
My Lord, Justice Tanko, we know each other well. So I don't want to point someone.
I was the one who stopped you, and I had made that sentiment that I think that if the Attorney General has had so much time to speak, I think that if you want to add something further, you should be allowed.
I'll just add one thing. I think I'll just simply add one thing. What I'll add is that, my lords, the provisions of the Constitution with regards to the underlying principles that is established with regards to democracy, the establishment of democracy. If we interpret Article 97(1) G and H, my Lord, just now go. No. I haven't talked about the level. No, it is not. My Lord, there's no art of finding a man's construction and a man's face.
Please finish
Yes.
your submission.
My Lord, should it be interpreted in a futuristic manner, it will totally undermine the rights of an individual to freedom of association. And Article 21 of the Constitution. It will mean that once you come into Parliament under one party or as an independent, you must remain there forever. That is simply, my Lord, what I want to add. And I thank you for the opportunity.
Mr. That is so. Your memorandum of issues, the 8, you still think they are all germane to the matters we are hearing? The 8 issues that you've raised, you haven't said anything about it. Nobody has said anything about the memorandum issues. So I just want to know whether all the 8 issues that you've raised.
My Lord, just as the reliefs, we focused on the reliefs relating to Article 97(1) J and H. The memorandum of issues 2, we will end at issue 4.
But 5 says you've mentioned Article 97(1) J and H. So if you end 4, what are you telling us?
We consolidate 1 to 4 deals with the vacation of office. At the memorandum 5 deals with whether the Speaker has the power to give the ruling to give or not. And my submission that it has, we've addressed it sufficiently in our statement of case.
Okay. Thank you.
Thank you.
Yes. I think I consider this issue to be very germane.
Okay. Thank you. Sit down.
Mr. Gatti, I think I missed something. Did you say you are relying on your first to fourth issues and abandoning the rest?
My Lord, I'm saying that first 1, 2, 3, 4 be taken as one, determines all the issues before the court.
So we should not expatiate on 5, 6, 7, and 8. What do you mean?
Issue 5 is also relevant. Issue 5 is also relevant, and we've addressed it extensively.
Issue 5 is also relevant.
Yes. And then issue 8. 6 and 7 can be abandoned.
By court, the judgment of this court will be delivered tomorrow, 12th November 2024. Yeah.
My lords are most grateful.
Lords, we are grateful. I mean, of course, being entirely the prerogative of the first defendant to file anything at all. Respectfully, I think that if the first defendant came before the court at the last agenda date, represented by counsel made representations before the court to file submissions at a certain point in time, elects not to do so, and then for no reason at all, elects also to appear before the court. Clearly, that is disrespect to the court. I made this observation because I'm the Attorney General, leader of the bar, and all that. Such conduct, with all respect, should not be tolerated by the court.
Leave it to us, Mr. Attorney General. Leave it to us. I would rather advise that as a member of the bar for which you are the leader, you should reach out to him at the close of these proceedings to find out if everything is all right.
My Lord, indeed, my friend, the Chief State Attorney, reached out to him on Friday to find out if processes have been done by him. So we've done our bit. Hardly did we expect that he would not even show courtesy to the court by not showing up. Thank you very much.
Honorable Attorney General, I think at the last agenda, if my memory serves me right, you also said, when we asked that you should file processes, he said he had instructions to deal with the matters that he did, and then
he will go for further instructions.
So, if he has not been employed again,
no, but my recollection is that that was before the firm agreement and then statement as to when processes will be filed by the court. That was before it. But that's fine. That's fine.
We have a lot
to deal with. That's fine. I'm very grateful.
Yes.
Right.
So if we retire early,
right,
because of the public interest in the matter, we should be able to serve the people in whose sovereignty resides.
Precise. I agree. It's perfect. I'm grateful.
Before you rise, my client, as we were arguing, the plaintiff came in. So we'll be grateful if it's possible.
We have signed the record.
Panel will be reconstituted. All rise.
Go and do your interview.